Relevance. Logical relevance is evidence is relevant if it tends to make the existence of any fact of consequence more or less probable than it would be without the evidence. Relevant evidence may be, but is not automatically admissible. Irrelevant evidence is inadmissible. Limitations on relevance. Logical relevance is not probative value. Evidence can have high relevance but low probative value. Discretionary exclusion. Courts can exclude relevant evidence if its probative value is substantially outweighed by its danger of unfair prejudice or confusion. Public policy exclusions. Evidence can be excluded in instances where allowing its inclusion could run counter to public policy considerations. For example, evidence of liability insurance, subsequent remedial measures, settlement offers, guilty pleas withdrawn, and offers to pay medical expenses. Discretionary exclusion of relevant evidence. A court may exclude logically relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, undue delay, or waste of time, according to FRE 403. Exclusion of relevant evidence often arises with evidence that is emotionally disturbing, repetitive, or confusing, admissible for one purpose but inadmissible for another, excluded to avoid risk of jury, using evidence for improper purpose. No unfair surprise to a party or witness is not a valid grounds for excluding relevant evidence. Balancing test. To exclude relevant evidence, probative value must be substantially outweighed by the danger of unfair prejudice. You should memorize this standard because the wrong MBE answer choices may use similar but incorrect language. I'll repeat. The balancing test is to exclude relevant evidence. Probative value must be substantially outweighed by the danger of unfair prejudice. Exceptions. Impeachment evidence based on convictions for crimes involving false statements is not subject to discretionary exclusion. Evidentiary hearing. Courts may conduct a hearing on admissibility of evidence or other preliminary questions, such as witness qualification, but must do so outside the presence of a jury. Exclusion of relevant evidence in public policy. Liability insurance. Evidence of liability insurance is not admissible to prove fault or a party's ability to pay damages. Evidence of insurance is admissible to prove anything else, such as ownership, control, or motive. Subsequent remedial measures. Evidence of repairs or other remedial measures taken after an injury is inadmissible to prove fault, defect, or inadequate warning. Remedial measures evidence is admissible to rebut a defense that there was no feasible precaution. Settlements offers to settle in plea bargaining. Civil cases, compromises, settlement offers, and related statements, including factual admission, are inadmissible to prove liability or fault. It does not include statements made before the claim or threat of litigation was asserted. Criminal cases. Pleas, offers to plea, and related statements. including factual admission, are inadmissible to prove guilt. Payment or offers to pay medical expenses are inadmissible when offered to prove liability for injuries. Related settlements, including factual admissions, are admissible. Offers to pay medical expenses in exchange for liability release are inadmissible, considered a settlement offer. Similar occurrences and habit. Similar occurrences is evidence of prior similar occurrences concerning the same time, event, or person in the present controversy is often inadmissible as irrelevant or as presenting an unfair risk of prejudice. However, similar occurrences may be relevant for other purposes. Admissible uses. Similar occurrences may be admissible to prove caution, prior accidents demonstrating either a pattern of fraudulent claims or pre-existing conditions, intent or absence of mistake, to rebut a defense of impossibility, value. Similar transactions can establish value, industry custom, to prove standard of care, or business routine to show that a particular event occurred. Habit. A person's habit may be relevant and admissible to show that the person acted in conformity with a habit on a given occasion. Conduct must be highly specific and frequently repeated, such as a person's regular response to a specific set of circumstances. Look for regular, instinctive, habitual conduct. Evidence that a person habitually goes down a particular stairwell 2 steps at a time could be admissible as circumstantial evidence that she did so at the time in question.